remind everyone that reporting restrictions continue to apply in this case. The victims are protected from identification by the Sexual Offences Amendment Act 1992. David Carrick, I have to sentence you for 49 offences on 2 indictments committed over 17 years while you were a serving police officer. Some of those charges represent multiple offences, and you have admitted at least 71 instances of sexual violence against 12 victims. You also took advantage of 3 of those women in brutal, controlling, and coercive relationships. These convictions represent a spectacular downfall for a man charged with upholding the law and empowered to do so even to the extent of being authorized to bear a firearm in the execution of his duty. Behind a public appearance of propriety and trustworthiness, you took monstrous advantage of women drawn into intimate relationships with you. You brazenly raped and sexually assaulted many women, some you barely knew. You behaved as if you were untouchable. You were bold and at times relentless, trusting that no victim would overcome her shame and fear to report you. For nearly 2 decades, you were proved right. But now, a combination of those 12 women by coming forward and your police colleagues by acting on their evidence have exposed you and brought you low. You have lost your liberty, your job, and your status. You have before you the prospect of a difficult time in custody for many years. You joined the Metropolitan Police in 2001. That put you in a unique position with exceptional powers to coerce and control. You will have sworn the oath taken by all police constables, which includes the following promise: I will, to the best of my power, cause the peace to be kept and preserved, and prevent all offences against the persons and properties of Her Majesty's subjects. In summarising the facts of the offences, I will not use names so that none of the victims lose the legal protection they are entitled to. You know who they are, and so do they. Nor is it necessary to repeat the detailed recital outlined by Mr. Little King's counsel in court this week. Certain themes emerge. Firstly, this violent sexual offending against women commenced almost immediately after you became a police constable, and you referred to your job when offending. Just over a year after gaining the office, while you were working in Merton Borough, you met a 20-year-old I will call T in a bar. You invited her to a housewarming party, which you said would be taking place at your flat nearby. You told her you were the safest person she could be with because you were a police officer. She went with you, reassured by this reasoning. There was no party. You held her against her will for hours. You raped her vaginally and anally, using violence to hold her down. When she struggled, you put a black handgun to her head. It felt real. But of course, she does not know if it was actually real, and it has not been recovered. She froze, terrified, believing you were going to rape and then kill her. When you raped her orally, you forced your penis with such power that she thought she was going to gag. You bit and bruised her during her ordeal. I have to sentence you on the basis that you used an imitation firearm, intending for her to believe that it was real, so as to subdue her to your will. This use of frightening objects, including police issue items, To assert authority and force compliance is the second theme I have identified. On the second indictment, these offences are represented by count 1, false imprisonment, counts 2 and 3, multiple vaginal rapes, counts 4 and 5, anal rapes, and count 6, indecent assault. Thirdly, you are so confident in the protection of your status within the police force and the difficulty faced by those who speak out about sexual abuse that you offended against all sorts of women, including 2 fellow police officers. On Friday, the 1st of October 2021, a woman made a complaint of rape against you dating back to August 2020. That was reflected in count 44 on the main indictment, in respect of which no evidence was offered and a not guilty verdict entered yesterday. However, when your arrest and charge for that offence in October 2021 was publicised, victims began to provide the accounts I have summarised. I have read the statements made by 10 of the 12 victims, both as to their experiences and the impact it has had. There is powerful and compelling evidence of irretrievable devastation in the lives of those you abused. Survivors of rape and coercive control react and cope in different ways. Those differences are apparent in the statements. Each one is traumatized. One woman feels as if she has been lost for the last 19 years, encapsulating her experience with you as an encounter with evil which has caused long-lasting psychological harm. Denial, anger, hatred, betrayal, shame, self-blame, and fear of being labelled a victim are common emotions. You have shaped their lives, deprived them of the ability to trust men and form relationships. Some have damaged mental health and suffer loneliness. They continue to question their own judgment. They don't trust the police. Some have tried to get back control by behaving in dangerous ways, self-harming, interfering with their own health and relationships, pushing boundaries and almost destroying trust in those they value the most. Those you controlled are trying to recover their self-esteem and lost relationships, including with a daughter who self-harms and still has nightmares because of your abuse of her mother. These women are not weak or ineffectual. They were victims of your criminal mindset. The malign influence of men like you in positions of power stands in the way of a revolution of women's dignity. It is remarkable that with one woman being driven to report an allegation against you, despite your position and power, others felt able to act. Even today, courage calls to courage everywhere, and its voice cannot be denied. You are 48 years old. You were aged between 28 and 45 when you committed the offences for which I have to sentence you. When interviewed about these crimes at various times following arrest, you either denied any sexual activity or other offending, or asserted that you always acted with the consent of the woman concerned. You pleaded not guilty to all charges when arraigned at hearings between December 2021 and December 2022. You changed your pleas in December 2022 and January this year. Beyond that, you have not expressed remorse or regret for what you have done, although you have demonstrated that these proceedings have had a grave impact on you, to which I will come. The criminality you have admitted may be called an unrestrained campaign of rape and abuse of women. It could be described as the work of a serial rapist, but it may not be possible to encapsulate succinctly the broad devastation you have caused through sexual violence and exploitation, all the time carrying the unique and defining office of a police constable. Various guidelines drafted by the Sentencing Council are relevant to individual offences, and some of the overarching guidelines also apply, including the Domestic Abuse Guideline. but it is not necessary for me to set out their contents in detail in these sentencing remarks, because the gravity of all subsidiary offending can be reflected fairly in the overall sentences for rape. Generally, throughout, there is high culpability and greater harm. The guideline for rape provides that sentences above 20 years imprisonment are appropriate for a campaign of rape. The prosecution submits that such sentences would be appropriate in the individual cases of at least 5 of your victims. The maximum sentence is life imprisonment. Apart from the guilty pleas, there is no material mitigation beyond your lack of previous convictions. I have to bear in mind that the total sentence must be just and proportionate, which means in this case that it is not right to simply add together all the sentences likely to have been passed for individual counts and impose the total. That would lead to a wholly disproportionate outcome. The defence have not served or relied on any psychiatric or psychological report on you. In order that the court had an independent professional assessment of you, I ordered a pre-sentence report. You described childhood trauma to the probation officer which must have affected your personality. You grew up with parents who drank to excess and neglected you. When they separated, you became the target of abuse by a stepfather in your teens. Like any child, you should have been nurtured and taught moral strength, and you were not. As an adult, you abused alcohol yourself, although you were able and careful not to do so when working. This indicates that you were able to control yourself when you chose to. There is no mental health issue beyond the inevitable depressive impact of custody. A less credible part of your account to the probation officer is your claim that you are unable to recall your acts of sexual violence and degradation towards women. I have to conclude that this is minimization because you are yet unable to face the enormity of the abhorrent acts you did while a serving police officer. The principal aggravating feature common to all the offences I'm dealing with is your use and abuse of the role of a police officer. All the victims were aware of your occupation and affected by it. Some of them you specifically reassured, tricked or intimidated, abusing the trust that the public vest in police officers. Furthermore, the sheer number of offences of rape is relevant to assessing overall criminality, and the domestic context in some of the counts represents a violation of the trust and security that normally exists between people in an intimate setting. Other aggravating features of particular offences include repeated violent rapes, including when women are unwell, ejaculation, false imprisonment to facilitate commission of sexual offences, use of an imitation firearm, a police baton and a whip to assault and threaten, monitoring women through a camera set up in your home, causing women to vomit during sexual violence, exploiting vulnerable women, presence of others, adult or child nearby, isolating women from their families, deliberate and sustained humiliation, when urinating on women, sometimes into their mouths, forcing them to swallow urine, forcing women to swallow semen, transmission of a sexually transmitted disease, offending in drink, and threatening to report a victim to immigration authorities. The Sentencing Council guideline on reduction in sentence for a guilty plea applies in your case by Section 73 of the Sentencing Code 2020. The court must take into account the stage at which you indicated your intention to plead guilty and the circumstances in which that indication was given. A sliding scale is applied. You denied all the crimes you were interviewed about. Until the admissions by way of guilty pleas, there was no acknowledgement on your part that the accusations made against you were true, and the police and complainants prepared for a trial. This case has been opened by the prosecution on a full facts basis. I would have allowed a reduction of 15% in sentence to allow for your guilty pleas to the majority of the charges which were entered in December 2022, with a trial date of the 6th of February 2023, having been fixed some months earlier. In respect of the earliest charges, those on the separate indictment on which you were arraigned only in December 2022, you indicated swiftly that you did not contest them, except count 7, which has been left on file, and you pleaded guilty in January 2023. I would have allowed 1/3 reduction. In reaching a conclusion on the correct level of credit for your guilty pleas, I have recognised the impact of one particular feature. Between July 2022 and December 2022, you were removed from Her Majesty's Prison Belmarsh and detained at the Rampton Secure Hospital. This was because the prison authorities feared you were suffering from severe depression, and after attending court on the 22nd of February, you had made a committed attempt to kill yourself. You were taken to hospital by air ambulance, returning to Belmarsh on the 28th of February. In defence statements served on your behalf on the 24th of May and the 14th of July, you claimed that what the witnesses complained about was either entirely made up or consensual. You were removed to Rampton on the 22nd of July for assessment and treatment. Thereafter, your lawyers had limited, if any, contact with you or news about you. It was only after the court intervened, seeking an update in your treatment, that on the 16th and 18th of November, the consultant psychiatrist responsible for you at Rampton Hospital provided a conclusion. This was that you were not suffering from any mental disorder requiring treatment in hospital, and you would be returned to Her Majesty's Prison Belmarsh when arrangements could be made for you to be kept under 24-hour surveillance to protect your life from another attempt at your own hand. Those representing you informed the prosecution and court swiftly after your return to prison that you would be pleading guilty. In the meantime, as I have indicated, the victim T on the separate indictment had come forward, and so further offences were laid against you. And as I've said, you changed your pleas to guilty in January 2023. In all the circumstances, I will allow 20% guilty plea reduction in the notional determinate sentence that would otherwise have been appropriate. I conclude from all the circumstances and information before me that you were driven to try to commit suicide as a self-pitying reaction to the shame wrought on you by these proceedings rather than from remorse. The starting point, it is agreed between the parties, is an assessment of dangerousness. Section 308, subsection 2 of the Sentencing Code, introduced by the Sentencing Act 2020, provides that where a court has to assess whether there is a significant risk to members of the public of serious harm occasioned by the commission by the offender of further specified offences, the court must take into account all the information available to it about the nature and circumstances of the offence, may take into account all the information that is available to it about the nature and circumstances of any other offence of which the offender has been convicted, may take into account any information before it about any pattern of behaviour of which any of the offences above forms a part, and may take into account any information about the offender which is before it. Serious harm is defined by Section 306, subsection 2, as death or serious personal injury, whether physical or psychological. This predictive assessment must be made as at the date of sentencing and on the premise that the offender is not in custody. The author of the pre-sentence report concludes that you pose a high risk of causing serious sexual and physical harm to the public and presently to yourself. I am sure the test is satisfied because of the persistence of your commission of serious sexual offences, particularly rapes, against so many victims over such a long period of time, which has already led to serious harm. I am sure that you present a grave danger to women who might be persuaded to be alone with you in intimate situations, and this danger will last indefinitely. I've considered guidance from Lord Thomas, the Chief Justice, in the Crown and Verinskas. I have to consider what form of sentence should follow this determination. Section 285 of the Sentencing Code applies to those offences you committed after the 4th of April 2005, which comprise the majority. I consider that the seriousness of the offences which I have to sentence you is such as to justify the imposition as a last resort of a sentence of imprisonment for life. Indeed, only such a sentence will meet the gravity of the offending I have to deal with you for, in combination with the risk you pose. Similarly, for the 5 offences of rape which fall out with the Sentencing Code scheme, I'm satisfied that life sentences are required to meet the gravity of the offending and the risk you will continue to pose. I have assessed very carefully whether, given your abusive position, this case should attract a whole life order. The rare sentence of last resort is a life sentence with a whole life tariff. In the Crown and McCann, Sinaga and Shah 2020 EWCA Crim 1676, the Court of Appeal Criminal Division examined conjoined cases involving serious sexual offending on a scale of extreme gravity. Although life sentences with minimum terms to be served of 40 years were appropriate after a trial, none of those cases reached the threshold for a whole life tariff in the view of the court. None of those offenders was a policeman, and the court did not have drawn to their attention any potential scenario close to the one presented to this court. However, the prosecution specifically does not seek to persuade me that your offending fits the description of, quotes, wholly exceptional circumstances, which the court indicated would justify such an order. I've also scrutinised the judgment of the court in another recent conjoined case, the Crown and Stewart, Cousins, Tustin and Hughes, 2022 EWCA Crim 1063, in which the offender Cousins appealed against the whole life order imposed on him, following a notorious abduction of a young woman from the streets of London, accomplished while he was an off-duty police officer by use of his warrant card, followed by her rape and murder. The court accepted that police officers are in a uniquely powerful position. In respect of the fixing of minimum terms where a mandatory life sentence is required by law, as set out in Schedule 21 of the Sentencing Code, a different scheme to the one I have to apply, Lord Burnett, Chief Justice, stated the principle, quote, in our view, the correct approach is to focus on the facts, which in a rare case might lead to the conclusion that a whole life order is appropriate, close quote. At paragraph 83, having explained the correct route to a whole life order in that case, he continued, quote, this was, as the judge said, warped, selfish and brutal offending which was both sexual and homicidal. It was a case with unique and extreme aggravating features. Chief amongst these, as the judge correctly identified, was the grotesque misuse by Cousins of his position as a police officer with all that connoted to facilitate Miss Everard's kidnap, rape and murder. We agree with the observations of the judge about the unique position of the police, the critical importance of their role, and the critical trust the public repose in them. End of quote. Had the court in McCann imagined the facts of this case, would they have equated it to the gravity of the near-miss mass murder attempt or the foiled terrorist atrocity, which the court considered would compel a court to attach a whole life tariff to a discretionary life sentence? The standout feature is the element of abuse of the status of a police constable, but having considered the matter with care, I've come to the same conclusion as the prosecution. Of the utmost gravity though this is, the wholly exceptional circumstances test is not met. Thus, the imposition of a discretionary life sentence without a whole life tariff must be accompanied by an evaluation of the notional determinate term that would have been required to mark the gravity of the total offending had a life sentence not been imposed. That term provides the start of the calculation required to reach a minimum term an offender must serve. It must be for the shortest term that is commensurate with the seriousness of the offences before the court. Mr. Williamson, King's Counsel, in his succinct and well-focused mitigation, submits that the criminality before this court does not reach the extreme limits found in the cases of the offenders McCann and Sinaga. I do not agree. Your offending was over 17 years and encompassed 12 victims. Moreover, the singular element which elevates your offending as a brutal serial rapist into that company is the principal aggravating feature of the explicit or implicit use of your occupation to entice, reassure, or intimidate your victims. You have to bear in mind that my function is to impose appropriate punishment, and when that is served, the parole board will decide how to protect the public thereafter. Decades will have passed before that time comes. I conclude that the notional determinate sentence that would provide a just and proportionate punishment is 60 years. To that guilty plea, a discount of 20% will be applied. It is to your credit that you did not contest a trial. Your decision deserves this recognition because there is no doubt that a court hearing at which evidence is given and challenged provides a particular ordeal for victims. From the resulting term of 48 years, I have to set 2/3 minus the time spent so far in custody, which is 491 days. Stand up, David Carrick. I've made ancillary orders for deprivation pursuant to Section 153 of the Sentencing Act 2020 and restraining orders under Sections 359 and 360 of the Act. They will remain in force until further order. The victim surcharge applies. I make no sexual harm prevention orders given the nature of the sentence I am about to pass. On the main indictment on counts 16, 19, 29, 30, 31, 32, 38, 39, 42 and 43, the sentence is 4 years imprisonment on each concurrent. On counts 24 and 25, the sentence is 7 years on each concurrent. On count 6, on the second indictment, I impose a concurrent determinate sentence of 9 years. 31 sentences of life imprisonment are imposed on the main indictment on counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 17, 18, 20, 21, 22, 23, 26, 27, 28, 33, 34, 35, 36, 37, 40 and 41. Also, 5 life sentences are imposed on the second indictment on counts 1, 2, 3, 4 and 5. This makes a total of 36 life sentences. The minimum term you will have to serve before the parole board can think of releasing you is 30 years, 239 days. And you may go down. Mr. Little, Mr. Williamson, the court salutes the courage of all the victims and their families, and I hope they're able to thrive in the rest of their lives. The teams of police officers concerned have worked hard to bring this case to court and to keep the confidence of the victims. To do so under the fierce scrutiny this case has attracted is promising for the future. The Crown Prosecution Service lawyers and counsel have met tight deadlines set by the court and put the case together fairly and effectively. The defence team has met the challenge of dealing with an evolving set of grave allegations and a completely disorientated client with patience and professionalism. The court wishes to recognise that work and to thank all of you.